for that in terms of his not being present today, it's not the result of some sort of infirmity or
Calm reflective narrator, slightly emotional but controlled tone, slower pace, the documentary closing style focusing on outcomes, probation terms, and final decisions.
some other matter that would prevent him from being here to testify.
All right. The 804 804B, no, 804A is the criteria for being unavailable, which is obviously the first step of this. A5, I see where you're headed with that. It's mostly A4. A5, however, states that the witness is absent from the trial or hearing and the statement's proponent has not been able by process or other reasonable means to procure his attendance or testimony. I think it would fall under that one, and based on the fact that there's been evidence under oath that he is out of the country, I would grant this motion for this trial had we had the trial. So I'm going to, like I said, it's a little different than the other. I think the other, with regard to the defendant's testimony, no matter when we go to trial, I will allow that. This one, if for some reason when the case gets reset, if Mr. Kale is not available at that time, I think we would also need to go through the same additional type of testimony. Hopefully he'll be back when this gets reset, but we'll reset it as quickly as possible. And then I will see if he's available. Obviously, we won't have to worry about this. If not, I'll need you to file it and we'll have a hearing on that at that time.
Yes, Judge.
All right? All right, you can go back with the bailiff. Thank y'all. Sorry about the scheduling issue.
Sorry. Thank you, Your Honor.
That's not good. She's here.
All right, ma'am, are you Lauren Bridges? And Ms. Bridges was previously in court, entered a plea of guilty to credit or debit card abuse. I received the pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor.
Are there any additions or corrections?
None more, Judge.
Just ask the court would order the restitution.
Just for the court's record, she's still in treatment, Judge.
The restitution in the amount of what?
It looks to be between 600 and 800, so I say we go on the low end,
Okay,
in all fairness.
yeah. Any issue with that?
No, Judge.
So I want to know more about treatment because it looks like there's a pretty serious issue, and what I had written down here was inpatient treatment, but
She went to treatment, was in treatment
Right.
before the warrant came out. She
Deep cinematic male voice, a slower pace, serious and emotional tone, documentary style with tension, highlighting rehabilitation, addiction, and court judgment.
and then once the warrant came out, she turned herself in, and then once she bonded out, she went back to treatment. Well, you can tell her what you're doing now.
Yes.
It was inpatient, it was in-house treatment, right?
at
I'm still in
Riverwalk Ranch.
Yes, still there.
So you're inpatient there?
Yes, ma'am.
And how long is that program?
It can be up to 6 months. I do have a recommendation, if it's okay, if I go from there onto sober living that they're infuriated with.
Mm-hmm.
On the 10th, I'm supposed to be graduating their program and going into sober living in Tarrant County, which is Fort Worth.
I have several letters from them. This was prior. I don't know if they're really applicable to this, but.
So February 10th is graduation day?
Yes, ma'am.
And do you have any information specifically about the sober living
I
place? Do you know what it'll be? Do you already know information about where the sober living is going to be, or will they tell you when it gets closer?
It's gonna be in Tarrant County, which is in Fort Worth, Texas. I don't know the exact, I'm not gonna know the exact address until the 10th. I could possibly get back there today and see if we can get an address
Okay,
today from
all right.
them, and I can send it in.
Okay. You'll need to obviously get that for probation, because the first step of once you're on probation is going to be to get your case transferred to Tarrant County.
Yes, ma'am.
And then whatever the requirements or conditions that I set, you'll be able to do there in Tarrant County.
Yes,
So any other issues, Ms. Smolfino?
It says in this letter, Judge, when a client successfully complies with the detox residential program, they're offered, encouraged to continue treatment through our partial day program and evening intensive outpatient program in Fort Worth, at the Fort Worth Recovery Campus.
Okay.
That's
And you
just the one
intend
that
on
they-
living it sober living and doing that as well? Whatever the outpatient is that they recommend?
yeah, that's what it is. It's PHP and IOP. So you go through the PHP first, which is like you do their housing, their sober living housing, and
Right.
you go to the classes during the day, during the week, and you work also. And then the IOP will be once you
Intensive
go
outpatient
to a
part.
different care.
Okay.
Level of care.
Okay, sounds good. All right, so it sounds like you're on the right path,
Yes,
Ms. Bridges. So I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney. Find you guilty of the state jail felony offense of credit or debit card abuse. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison. But I'm going to probate that for 5 years. You're ordered to pay the $500 fine, also ordered to pay $600 in restitution, excuse me, and to follow all of the rules and conditions of probation. That is going to include continuing and graduating from the Riverwalk inpatient program that you're in now. Also following through with whatever their recommendation is for outpatient care, the sober living. I'm going to allow you to do all that, but I'm not going to just allow you to do it. I'm going to require it. Okay, so you can't leave there until or unless they say that you have gone to the next step, or you are an outpatient, you can live on your own and all of that. Part of your order now and part of your probation is going to be to follow all of those recommendations, okay? If you do everything you're supposed to, this is a great opportunity, because for all practical purposes, your case here in court is over, and you'll be able to serve that 2-year sentence while you're out on
Male documentary narrator, a neutral American accent, the steady pace, professional courtroom tone, clear and informative delivery.
probation. The other side of that, though, is if you violate any condition of probation, if you relapse, if you end up committing a new offense, whatever it is, then you're going to be back here in court and you're going to be facing that 2-year sentence that you just agreed to. Do you understand? Also, it's important that you know when your probation gets transferred to another county, it's still here. I still am in charge of your probation. So you kind of have double duty. You'll be able to go in person, obviously, and do everything you're supposed to there in person in Tarrant County, but you are going to be required to either by mail or online check in here and report. So you've got to report in person and online or by mail here. If you don't do one or the other, you have to do both of them. So don't forget that. A lot of people will just kind of forget about Jefferson County, but this is where it all stems from, and you could end up back here in prison, okay? I'm handing you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I've also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provided you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Parker. All right, if you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Good luck to you, ma'am. Allison Strom, Mr. Parker, it's a sentence. Good morning, sir. Are you John Roy?
Yes, ma'am.
And Mr. Stringfellow, will your client waive the formal reading of the indictment?
Yes, ma'am.
Mr. Roy, in cause number 25, DCCR 1365, you're charged with the state jail felony offense of driving while intoxicated with a child under 15, and that's from July 3rd of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? and because you did what they charged you with. I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Stringfellow? Do you fully understand them?
Yes.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you've reached is for a 2-year term in the state jail prison, but that would be probated for 4 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1, Mr. Stringfellow.
Yes, no objections.
It's admitted. Is there any evidence that Mr. Roy is not competent? All right, Mr. Roy, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case so that the probation department can do a pre-sentence report.
Couple of things, Judge. The agreement contemplated an interlock device. I don't know if we put that in the paperwork. And another thing, Judge, I don't know if the court would entertain, Mr. Stringfield and I talked about this, maybe waiving appeals on this case.
Okay, let me, can you send me that paperwork back, Anna, and I'll write, that's your agreement, is that he would have an auto ignition interlock device
Yes,
on
ma'am.
any vehicle he drove?
Yes, sir.
No history that that you
Judge,
can,
The state's file reflects a 1994 operating a vehicle by intoxication. That's out of the state of Louisiana. And a couple of arrests, an arrest for battery in 2008, another arrest for battery in 2019. Other than that, no other criminal history. My understanding is that the defendant is from Louisiana.
Yes, he resides in Louisiana.
okay. So, with everyone's permission first, can I make that right in on that agreed punishment recommendation page, the agreement for the auto ignition interlock device?
No objection.
No objections.
All right. So then what I'm going to do, Mr. Roy, based on Mr. Coleman's representations with regard to any real lack of criminal history, is waive the pre-sentence report. So again, make that finding that you entered that plea freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, follow the agreement that you made with the district attorney and find you guilty of the state jail felony offense of driving while intoxicated with a child passenger. Sentence you in accordance with that agreement to a term of 2 years in the state jail prison, but I'm going to probate that, so you're on probation for 4 years. You're ordered to pay the $1,000 fine and to follow all of the rules and conditions of probation. That includes having the auto ignition interlock device on any vehicle that you drive. You cannot drive a vehicle unless it has that. You'll talk to probation today here in the courtroom. She'll probably send you over to the probation office at some point. It's important you give them all the information of where you live so that they can work on the proper process of getting your probation transferred over where you are, okay? I'm handing you now the trial court certification. That shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney. All right? Good luck to you, sir. Make sure you stop and talk to probation. She might be ready for you now. She might have you have a seat and then visit with you. Yes, sir.
He currently has a portable device. Do you think it's possible for him to keep that device instead of installing a permanent machine into his vehicle?
Mr. Coleman, what's the state's position with regard to the portable?
Not necessarily opposed to that, Judge.
Is it it's not required on the state jail felony for him to have, for me to make a finding on the auto ignition interlock. It's not. Okay, so what I will do is have probation place that if he has the portable, he doesn't have to have the auto ignition. If there's any issues at all with missing portable, if you miss blowing or it's whatever happens with that, number one, it could be a violation of your probation, or it could require maybe having both, or whatever it's gonna take for me to feel like you're safe out there on the road. But keep doing the portable for now. I'll take away that interlock requirement unless there's some issue that comes up that makes me feel like